Judge Liman issued an order today regarding the Wayfarer motion for alternative service of the subpoena to Isabela Ferrer. He denied the request to serve by alternative means, and he also denied the sanctions sought by Ferrer's attorneys. The court's reasoning is that the Wayfarer parties did not provide a reason to believe that Ferrer could have been served at those two addresses. So I had to go back to the briefs and check, but I thought that I had read in one of Fritz's letters that it was Lively who provided the addresses that they used in Lively's initial disclosures, which would be evidence that the court is saying that Wayfarer didn't provide. So it seems that the court is ignoring Exhibit A attached to Wayfarer's reply brief. And typically, you're not really encouraged to provide new evidence or new arguments in a reply brief. So a reply brief is what is filed after an opposition is filed. And in the reply brief, Fritz attached in his declaration something that we can't see, but a copy of the initial disclosures that he is saying contained the addresses that Wayfarer relied on. And the court here seems to be punishing Wayfarer for not having put that in the opening brief, meaning the first brief, the first motion, where they are required to show due diligence. The court completely ignores that aspect of the reply brief and doesn't even explain why it ignores it. I would be really frustrated if I was Wayfarer's counsel with this order. But it is a lesson to litigators that put all your evidence in that shows everything in your opening brief, because it has happened that judges will just ignore what you put in a reply brief. But here it's clear that the judge didn't completely ignore the reply brief because he references the reply brief. Specifically, it quotes that the Wayfarer parties explained that they did not provide this information because doing so seemed unnecessary. But they went on to include a copy of the initial disclosures that presumably had those addresses. So I don't know. I think this is a little overly harsh from the court. That being said, he ruled it without prejudice, meaning that they can try to serve again. They could even bring the motion again, but this time showing how they did their due diligence to find the address and serve at that correct address. The court goes on to deny the sanctions that Ferrer sought because it says that she hasn't even been served with the subpoena, so it's premature to do the inquiry of whether or not the subpoena is overly burdensome, and reminds Ferrer that if she has objections to the subpoena, the proper method of doing so would be to object and move to quash. He has also ruled that without prejudice, allowing them to come back if they want to seek sanctions still. What this means is that Isabela Ferrer is still at play, meaning that Wayfarer can still try to serve her with the subpoena, and if she should evade service or there are some other challenges with her failure to comply, then Wayfarer can seek the appropriate remedies at that point in time. But we're not there yet. If we are, we will discuss it at that point. As I suspected, the court ignored all the stuff about the indemnification and the harassment language, yada, yada, yada. The court ignored all of that because that is not the question before it. I would hope that at this point, the lawyer representing Isabela Ferrer would just accept service and they can fight about the extent of the subpoena like normal parties would. My suspicion is that they just wanted that brief, that opposition brief, to be filed and for those ensuing headlines to come out, and that now they will cooperate with the Wayfarer parties.